in these prior videos on our secret weapon in foreclosure, the Consumer Financial Protection Bureau protections, we talked a little bit about how the protections work and the fact that these are federal regulations that apply to federally regulated mortgages and that they're a very big benefit to consumers. In the second video, then, we talked about what happens when you submit loss mitigation and how the banks are supposed to be processing more effectively, and quite frankly, in my experience, I think they are. But what's happening, unfortunately, across the state of Florida in particular, in my experience, is we're having courts that are telling consumers and their bank representatives that I don't care that you and the bank have worked something out. I don't care that you're in a modification or short sale or anything else. We have this mandate from the Supreme Court of Florida, which I call the foreclosure purge, and that foreclosure purge issued by the Supreme Court takes precedent over these federal regulations. Now, it just doesn't make practical sense. It just doesn't make good sense in any way, because we've got the federal government issuing mandates to those entities that are regulated and are issued their charters by the federal government to provide very robust consumer protections. And in many, many instances that I'm personally and intimately familiar with and aware of, the banks are doing a very good job. They're taking that second, that third, that fourth review of our consumer and saying, you know what, we think it makes more sense to keep this elderly person in the home making a modified mortgage payment than it does to just set this house out for a foreclosure sale where we, the bank, are not going to net a value that we think is appropriate, and we're just going to turn into another blighted property, and this person is just going to get thrown out into the street. So again, what we're experiencing here at the ground level is we've got banks and consumers working together as the CFPB regulations contemplate, and in good faith working together, and yet when they stand in front of a judge, maybe there's a trial scheduled or summary judgment, and you've got a very diligent bank attorney standing there, and the attorney says, Judge, we've got a modification worked out here, and we think it's in the best interest of Mrs. Smith, this elderly, disabled person that lives in your community, for us not to go forward with this foreclosure sale or not to go forward with this foreclosure trial. And I've seen it again and again and again in courtrooms where the judge says, I don't care about that. You're going to go forward with this sale, or you're going to go forward with this trial, because that's the mandate we've gotten from Tallahassee. Again, it just doesn't make good sense. Well, but what do we need to do about that? Well, I'm holding in my hand here a counterclaim that we filed in a case which cites the specific Dodd-Frank regulations here and the bases for that, and basically that under 12 CFR 1024, the servicer is required to engage in that robust loss mitigation activities, and by going forward with a foreclosure trial or foreclosure sale, they're violating that. Now, we filed this motion some time ago, and quite frankly, it took some time for the servicer to review that, but I'm very, very pleased to report that even though the court had denied the relief that we were requesting, or in fact demanding in here formally in this counterclaim, we have become very effective partners, the plaintiff's attorney and I, working on behalf of my client and that plaintiff's client to come up with a resolution here. So again, understand how this functions. I initially filed a counterclaim to try and stop a trial. The court denied that. The sale's going forward, but then after the fact, I get very high-level cooperation from attorneys within the law firm saying, you know what, the best interests of this community are served by the bank and the consumer working together to try and solve something. And so, again, I give the banking industry quite a lot of credit for working together with consumers and paying attention to Dodd-Frank regulations. Now, I encourage all of you to pay very close attention to these Dodd-Frank regulations, because they're effective both before foreclosure gets filed, modification. They're effective during a foreclosure case because they can result in a stay of proceedings. And then finally, they're effective after the foreclosure case happens because they can still help to prevent a sale. I'll talk about that in this final video here, what happens when everything goes wrong and how to use Dodd-Frank to protect you there.